Hello and welcome to the 6th online podcast for LWS011 Journalism Law. I'm Peter Black. This week we begin to turn to the law as it relates to information, and in particular we're focusing on journalists keeping secrets. And there are a few different aspects to this particular topic. The two that we're going to be focusing on today, it relates to breach of confidence as well as some of the legislation that applies to the disclosure of journalists' sources. So a little bit of background then. Over the past 2 decades, a few Australian journalists have been jailed for refusing to reveal their sources to a court. Now this represents a three-way clash of interests between the journalist sources, and the legal system itself. And so what we're going to do this week and next week is look at some of the law that pertains to this clash. So the accessing or disclosing of sources of information can raise several different legal issues. There is what's referred to as the breach of confidence doctrine, which is publication of information that others may wish to keep confidential, including disclosures by whistleblowers, as well as attempts by journalists to keep their own confidential sources. Those are the two topics that we'll focus on this week. Next week, we'll look at accessing government information by means of freedom of information legislation. Now, also relevant to this particular topic is what's described as disobedience contempt, which occurs when individuals defy an order of the court and refuse to reveal their sources. Now, while the textbook talks about disobedient contempt in relation to this particular topic, we will consider disobedience contempt when we look at the wider law relating to contempt of court a little bit later on in the semester. So we're going to begin this week by looking at breach of confidence. So, what is breach of confidence? Basically, an action for a breach of confidence provides a legal mechanism for keeping secrets. And there are 3 elements to be proved by someone seeking to restrain the publication of confidential information. And so these are the 3 elements that you need to be able to apply. First, that the information was indeed of a confidential nature. Second, that the information was communicated in circumstances importing an obligation of confidence. And thirdly, an actual or threatened unauthorized use of the information to the detriment of the person who communicated that information. So, and what we'll do now is go through and consider each of these elements in turn. First, the information has to have this necessary quality of confidence. Now, this can be easily recognized in the case of business or trade secrets or other commercially valuable information. It will have that quality of confidence if it is some sort of business or trade secret or some sort of commercially valuable information. So, for example, a concept for a TV program or photographic images of the wedding of 2 famous actors. It also extends now to the protection of personal secrets and sexual affairs. So it's not just talking about business or trade secrets or commercially valuable information. It extends to personal secrets and sexual affairs. It can also perhaps, in some circumstances at least, cover a person's identity as well. Interestingly, government information may also have the necessary quality of confidence. But when we're talking about government information, the notion is a little bit more restrictive. So if the information relates to government or its operation, there is an extra requirement. Namely, it must be shown that its disclosure would be contrary to the public interest. So it's not just enough when we're talking about government information for it to be considered confidential. Its disclosure would have to be considered contrary to the public information. See, for example, Attorney General and Jonathan Cape Limited. In that case, a cabinet minister kept detailed diaries recording cabinet discussions and political events with a view to their publication as a book at a later date. Following his death, the first volume of the book was published, which disclosed details of cabinet discussions, revealed differences between members of the cabinet, and disclosed advice given by civil servants. Extracts from the book also appeared in a newspaper. The Attorney General sought an injunction against the cabinet minister's executors, the publishers of both the book and the newspaper. The court ultimately held that the application should be dismissed, concluding that although that initially this information would have had that necessary quality of confidence, its disclosure now would not be contrary to the public interest. It may have been at the time, 11 years earlier, but it was not today. Now, when we're talking about government information in this context, it includes information about government and its workings, including information on national security issues, foreign affairs, or information that would prejudice the ordinary operations of government. It does not apply to confidential information the government may hold that relates to private individuals or companies. Now, once the information has entered the public domain, it will have lost its quality of confidence, and this can be illustrated by the famous case known as the spy catcher case. So, what was going on in that case? So, a person called Wright was a former member of the British Secret Service and had gone to live in retirement in Tasmania. There he wrote his memoirs, titled Spy Catcher, which alleged irregularities in and in the carrying out of unlawful activities by members of MI5. Now, by reason of the British Official Secrets Act, the book could not be published in the United Kingdom. Accordingly, Wright attempted to publish the book in Australia. The British government sought to restrain such publication, including some of the allegations made by Wright being reported by newspapers in the United Kingdom. Proceedings were then commenced in the UK to further restrain publication by these newspapers. Now, ultimately, of course, as you might imagine, this litigation served to boost the worldwide sales of the Spy Catcher book, particularly in the United States, and illicit copies began flooding into Britain. Further, a British newspaper, the Sunday Times, purchased the British serialisation rights to the Spy Catcher and published the first instalment of extracts from the book. Now, one issue in this case, there were many issues in this case, but one issue in this case was that the publication was not able to be restrained in Australia because by the time Spy Catcher had come onto the scene, a vast amount of material about MI5 was already in the public domain, in the form of a large number of additional publications, broadcasts, newspaper and journal items, including material authorised by MI5 itself in order to generate a favourable opinion. And so the conclusion of the judge in that case was that the material had already been in the public domain by the time it was commissioned by the publishers and written by Wright. So it had lost its quality of confidence. Also on this notion of quality of confidence, information may be disclosed to a limited number of recipients without losing its quality of confidentiality, provided there is relative secrecy. And this is illustrated by the case of G and Day. In G and Day, the plaintiff's name in that particular case had been published, but only on TV news, and those references were transitory and brief, his name only being mentioned once on each occasion and not recorded in any permanent form. And so the view was that there was still relative secrecy in that particular case. The unexpected authenticity or veracity of the source of information can also be an important consideration here when trying to determine whether the information has that necessary quality of confidence. And the point here is that speculative gossip, innuendo, and assertions by unknown persons on the internet may not be sufficient to regard information as having moved into the public domain. And we can see this in the important case of the Australian Football League and The Age. So, what was going on then in this 2006 case? Well, 3 players were alleged to have breached the Australian Football League's illicit drugs policy. Under that policy, the first 2 positive test results were to be kept confidential between the player and the AFL. A third positive test resulted in the player being referred to the AFL tribunal for sanction and the matter becoming public. Now, the AFL and the Players Association in this case sought permanent injunctions restraining 2 newspapers from disseminating any material that would identify any AFL player who tested positive under the policy and a declaration that the identity of such player was confidential. In return, the newspapers claimed that the information had passed into the public domain because the identity of the players concerned had been published on a number of online discussion forums. Further, a viewer of the Foxtel television program Fox Footy had called the program hosts on air and named a player as being one of the players concerned, although the hosts of the program had entered into no discussion about the matter. Now, it was held here that the mention of the name on the Fox Footy program by the caller was momentary, speculative, and heard by a limited audience, and that further speculative gossip, innuendo, and assertion by unknown persons on websites do not place the name into the public domain, notwithstanding the fact that many people may well have seen the names. So the public, and particularly that part of the public who uses internet chat rooms, the court said, had no expectation of authenticity or veracity of the information posted on those websites. And so it maintained the necessary quality of confidence. The next element is that there must be an obligation of confidence. So the first element is that it has to have this quality of confidence about it. The second element is that there has to be this obligation of confidence. Now, information must be received in circumstances imposing upon the recipient an obligation of confidence. And the courts here look to whether the person who received the information knew it was confidential or ought to have known it was confidential. Now, it's worth noting here that you don't have to use the words "this is confidential" in order for something to be confidential. You can consider it as confidential from the circumstances. And so the relevant circumstances are going to include information received pursuant to a contract or information received in the course of a relationship, including a contractual or fiduciary relationship. It may catch a third party to the original confidence if that third party knows or ought to have known that the information is confidential. Now, this is particularly relevant here for journalists and the media. Indeed, most litigation of this kind is directed at the messenger, that is, the journalist or the media, and not the original source of the leak, especially where the source may be unknown. Of course, no obligation arises if the recipient already had the information or was able to obtain the information from somewhere else. The third element is that there must be an actual or threatened unauthorized use of information. Now here the risk must be real and not just fanciful or theoretical. Do you also need detriment though? And there's slightly different opinions here as to whether you, in addition to there being an actual or threatened unauthorized use of information, there needs to be detriment suffered by the plaintiff. Usually it's considered generally sufficient if there is just embarrassment or if the confider is exposed to public discussion and or criticism. So as a relatively low bar in terms of whether there is any detriment required. Let's now consider the main defence that exists when we're talking about breach of confidence. So there is a defence to an action for breach of confidentiality where there is just cause or excuse for breaking this confidence. In England, this defence was originally confined to the disclosure of iniquity, but for some judges it now involves balancing just cause or excuse, where the public interest in publication outweighs the public interest in maintaining the confidence. Now, in Australia, courts generally haven't been prepared to venture so far and instead apply what's described as the iniquity rule or the iniquity defence. Now, the most relevant case here that considers this is the Australian Football League case and the age. So, again, in that case, the court held that in order to rely on the so-called iniquity rule, the defendant would need to establish the following: that the proposed disclosure will in fact disclose the existence of or the real likelihood of the existence of an iniquity that is a crime, civil wrong, or serious misdeed of public importance, that the iniquity to be disclosed is of a character of public importance in the sense that what is to be disclosed affects the community as a whole or affects the public welfare, and that the person who is seeking to protect the confidence is doing so in order to prevent the disclosure to a third party with a real and direct interest in redressing the alleged crime, wrong, or misdeed. The court held that applying this test, that the disclosure of names of football players who had tested positive to illicit drugs would not disclose any iniquity of serious criminal nature, and therefore they were not able to rely on that rule. Okay, so what then are the remedies? Well, only a confider may obtain a remedy. You might be able to obtain an injunction. An interlocutory injunction requires there be a serious question to be tried, and with the balance of convenience must be in favour of the grant of the injunction. Where a third party not subject to the original interlocutory injunction publishes material that was subject of the injunction, that party may have committed a criminal contempt. So that then brings us to an end of the cause of action for breach of confidence. I did, however, want to also make some comments about whistleblower protection as well as disclosure of journalist sources under both common law and legislation. So let's begin by looking at whistleblower protection. Now, there's legislation that exists in Queensland, New South Wales and South Australia that allow whistleblowers to give information to the media in different circumstances. The relevant provision here in Queensland is the Public Interest Disclosure Act. It's also worth noting to see what the MEAA Journalist Code of Ethics states on the disclosure of journalist sources. So Clause 3 of the Code of Ethics states that journalists are to refuse to give an undertaking of confidentiality to a source without first considering the source's motives and any alternative attributable source. However, once given, a confidence must be respected in all circumstances. So, a little bit of context here. First, it's worth noting that it's a defence to a breach of confidence cause of action that you are compelled by law to disclose a source. It's also worth noting that a witness who fails to answer a question commits a disobedience contempt of court. Journalists, however, are often given an assurance of anonymity in return for information, and journalists argue that a privilege based on public policy in ensuring sources are prepared to come forward and that the flow of information is not impeded. At common law, however, the argument in favour of a journalist's privilege has been rejected. In Australia, courts are traditionally regarded as having some discretion here. So disclosure of identity of sources is generally not compelled by a judge unless disclosure is necessary in the interests of justice. This is sometimes described as the newspaper rule. So there is a rule of practice that except in special circumstances, newspaper defendants in defamation actions are not forced to reveal the identity of sources at an interlocutory stage. That is, at a preliminary stage. The rule does not apply to commissions of inquiry. The rule only applies to newspaper publishers, proprietors, editors, and full-time journalists. It does not apply to television. It does apply to television and radio. The rule is not absolute, and it will not apply if the applicant can show disclosure at an interlocutory stage is necessary in the interests of justice. So, what does this mean in terms of pre-trial discovery orders? There is an equitable procedure for discovery enabling a victim of a wrongdoing by an unknown wrongdoer to apply to a court for an order directing a person to disclose the identity of the wrongdoer. Again, disclosure will only be compelled where it is necessary in the interest of justice. In Australia, provision may be made in most states, but not in Queensland, for discovery for the identity of an unknown wrongdoer in the court rules of court, but only for the purpose of enabling the applicant to commence legal proceedings against the wrongdoer, and the newspaper rule cannot be relied upon as a basis for refusing to grant an order for pre-trial discovery, although the policy considerations behind the rule will be taken into account in the exercise of that discretion. Now, the position under statute, though, is a little bit different. The Commonwealth law now provides for shield laws for journalists in federal courts in the form of a rebuttable presumption of non-disclosure. This is now contained in Section 126, capital H of the Evidence Act. So if a journalist has promised an informant not to disclose the informant's identity, neither the journalist nor his or her employer is compelled to answer any question or produce any document that would disclose the identity of the informant or enable that identity to be ascertained. The court does, however, have the discretion to order, but this does not apply. A similar provision now exists in New South Wales, but there is no equivalent provision in Queensland. So that is a risk journalists have to take in the state of Queensland. Okay, that then brings us to an end of this brief podcast for the material in week 6 relating to keeping secrets and confidential information.